Companies Act, Section 119, Inspection of Minute Books of General Meetings. Section 119 of the Companies Act establishes the right of company members to inspect and obtain copies of the minutes of general meetings and resolutions passed by postal ballot. This provision ensures transparency and accountability in corporate governance by allowing members to verify corporate decisions and participate in the company's affairs. The section also outlines 1. Where the minute books should be kept and their accessibility for inspection. 2. The rights of members to request copies of minutes and the applicable procedures. 3. Penalties for non-compliance in case a company refuses inspection or fails to provide copies. 4. The role of the tribunal in enforcing compliance. 1. Location and availability of minute books for inspection. To ensure accessibility, the minute books containing records of general meeting proceedings and postal ballot resolutions must be a. Stored at the registered office. The company is legally required to keep and maintain the minute books at its registered office. This allows members, auditors, and regulators to inspect them as needed. B. Open for inspection during business hours. The minute books must be available for inspection by any member of the company during business hours. The company may impose reasonable restrictions on inspection, but such restrictions must be set out in the company's Articles of Association or passed through a resolution in a general meeting. At least 2 hours per business day must be allotted for inspection. The company cannot charge any fee for inspection. Members can inspect the records free of cost. 2. Right of members to obtain copies of meeting minutes. Any member of the company has the right to request a copy of the minutes recorded in the minute books. Submit a written request to the company for the copy. Receive the copy within 7 working days from the date of request. Pay the prescribed fee as set by the company's policy or regulatory guidelines. This ensures that members have timely access to key decisions taken at general meetings and can verify whether these align with their interests. 3. Penalties for non-compliance. If a company refuses to allow inspection or fails to provide a copy of minutes within the required time frame, the following penalties apply. A. Penalty on the company. The company is liable to pay a penalty of 25,000 rupees for each instance of non-compliance. B. Penalty on officers in default. Every officer of the company who is responsible for the default is liable to pay a penalty of 5,000 rupees for each instance of non-compliance. This applies to directors, company secretaries, and any other relevant officers who were responsible for ensuring compliance. These penalties serve as a deterrent against non-compliance and reinforce the importance of maintaining corporate transparency. 4. Tribunal's power to enforce compliance. If a company refuses inspection or fails to provide copies of minutes, the affected member can escalate the matter to the tribunal. A. Powers of the tribunal. The tribunal may issue an order to direct the company to allow immediate inspection of the minute books. Compel the company to send the requested copies to the member without further delay. This provision ensures that members do not suffer due to the company's non-compliance and provides a legal remedy to enforce their rights. 5. Importance of Section 119. Enhancing transparency, members can inspect and verify key corporate decisions, fostering good governance. Protecting shareholder rights. The provision ensures that shareholders can access and review company decisions affecting their interests. Encouraging compliance. Strict penalties discourage companies from withholding or tampering with records. Ensuring legal recourse. The tribunal's intervention powers ensure members are not denied their statutory rights. For more details, contact us.